Hey everybody. Good afternoon. Oh, it's still morning. Good morning. We got about 7 more minutes of the morning over here on the east side. But good morning, everybody. Hey Angie. Hey Green Eyes. Hey Pretty Brown Eyes. Um, so I'm gonna go ahead and get started because as I told you guys, today is gonna be a very, very busy day for me. So I am going to go ahead and just bring you guys this update. I may not read the whole paperwork. I might give you some snippets of it. Hey Z, hey DZ. So I'm just going to give you snippets of it. If I'm permitted and if enough time, I'll probably go ahead and read it. 77 pages of this, and I'm not going to read the table of contents and all that, but I'm going to give you the meat and potatoes of the filing. Okay, it's not going to be that long, so let me just go ahead and bring this up to you. All right. Jennifer has filed the brief for the Illinois Northern District of Illinois case where Mr. Kelly was found guilty of I think it was 6 of the 7 charges, because 7 charges he was found not guilty of. But these are the charges that Jennifer's put an appeal for. Okay. So, this Putty Cat. Hey, Putty Cat. Let's go ahead and get started. All right, here it is. The 7th Circuit of United States Circuit Court, 7th Circuit. This is where the Illinois case is. Case number 23-1449. United States Courts of Appeal, which is the 7th Circuit Court, United States versus Robert Sylvester Kelly. He is the appellant and the United States is appellee. The appeal is from the United States District Courts of the Northern District of Illinois, Eastern District, and the case number that the appeal is on is case number 19 CR 00567, where the judge had our honorable Judge Harry Lineweber was the judge that was on the bench. And it says here the brief and requirement short appendix, and is submitted by Jennifer Bongine and Ashley Cohen of the Bongine Law Firm. Okay, here's the form that they submitted in, and it just basically gives the whether or not the appearance in the court circuits Rule 26 disclosure of statement. This is a statement that they have to submit along with the appeal brief. Okay, it says here is an enable to the judges to determine whether the recruiter of a necessary or appropriate or an attorney for a non-governmental party. Okay, I don't need to read all that. It's just some paperwork. It's just boring stuff. Okay, let's go on to the meat and potatoes of this. Okay, if you want to read this, you can get a copy yourself, but this is like the boring stuff. This is just the normal stuff. Okay, let's go to the table of content. And what we really want to look at is the case of the statement of the case, the judicial statement, statement of the issues. And here they have the evidence related to Jane, evidence related to Nia, evidence related to Pauline, right? And then you're going to have the argument, summary of the arguments, and it's going to, and it looks like, number 1, he says, I'm going to read this part. It says here, defendant conviction for exploitation and inducement of the child must be reversed. Here's why she's going to give why it should be reversed, right? Where the charges were brought outside of the applicable statute of limitation. Remember we talked about that before, statute of limitation. They brought into that law so they could bring in the statute, go beyond the statute of limitation. So we're going to read her argument on that, right? Then number 2, the trial court abused its discretion when it denied defendant's motion to sever the induced counts 10 through 13 from the child P counts related to Jane, count 1 through 3. Then the third argument is defendant's 240-month above. See, this is, where's Misguided? Misguided, where's she at? Misguided, are you in this chat? Where's Misguided at? Miss Guide, are you here? Where's she at? Hey, Black Beauty. Miss Guided, where are you? Where's she at? Because I wanted to talk, because her and I, when we were in court, and we were saying how basically the judge given him over the amount of what was standard. Because remember, he said, even though you were found not guilty in the conspiracy part, but I feel that you conspiracy was done, blah 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 blah, and so therefore I'm going to give you blah 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 time. You get what I'm saying? So okay, thank you, Latoya. So yeah, we talked about that. Miss Guy and I talked about that when we were at court. Yeah. We did talk about that. So she is going there because she says here the defendant's 240 months is above guideline sentence was both procedurally and substantively improper. Mm-hmm. Mm-hmm. We said it. We're not even attorneys. We said it. It was like the judge was giving them a gift because that's going to be something that's going to be done in in at okay. Here's all the authorities, the cases that she referenced in this case in her argument. Okay, you see all these cases here. I'm not going to read all of them because it's going to take up some time. Hold on, all these cases right here. The statues right here, statues, and then the other authorities, and this is some other thing, Child Abduction Act, Amber litigation. Okay. Okay. Here is its judicial statement. All right, here we go. Number one, here we go. The judicial statement. Judicial statement and jurisdiction of the United States District Court of the Northern District of Illinois was founded upon 18 U.S.C. 3231. A grand jury sitting in the Northern District of Illinois charges defendant by way of indictment with 4 counts of child exploitation in violation of 18 U.S.C. 2251A, 1 count of conspiracy to obstruct justice in violation of 18 U.S.C. 371, 3 counts of conspiring and receiving child P in violation of 18 U.S.C. The reason why I'm saying child P, because I'm trying not to say that word in this thing, because for some strange reason, YouTube kind of like frown upon certain words, and that's one of the words they do in the other word, the S word. So I'm going to be P and S and throughout this whole thing, okay? Please bear with me with that. Child P in violation of 18 USC 2252A2 and B1, and 4 counts of child exploitation in violation of 18 USC 2422, docket number 93. The jurisdiction of the United States Court of Appeal for the Seventh Circuit is founded upon 28 USC 1291 and 18 USC 3742. A jury returned a verdict finding defendant guilty of 3 counts of 18 USC 2251 and 3 counts of 18 USC 2422. And on September 14, 2022, docket number 335, defendant post-trial motion were timely filed on November 15, 2022, docket numbers 387 and 388. The post-trial motion were denied on February 16, 2023, docket number 416. Defendant was sentenced on March 7, 2023, docket number 428. The judgment and conviction was entered on March 7, 2023. Docket number 428A. Notice of appeal was filed on March 9th. Docket number 431. The statement of the issues for review. Now, here's where she is going to give you the problem with the whole thing that she is misguided. I was calling you. Remember when we were having a conversation in regarding to what Judge Lineweber said? And remember he was saying that even though that Robert was not convicted of conspiracy, but he felt that he was guilty of it. But even though the jury found him not guilty, and he decided to give him more time. And remember we were saying that something about that in itself is like a gift from the judge, because we know he shouldn't have gave him that additional time. Remember we were talking about that? I don't know if you remember, but Jennifer is addressing that, the over sentencing him with the amount of time based on that. Yeah, we talked about that, didn't we? I was just trying to call you because we referenced that. All right, let's go. Number one, whether defendant's conviction for exploitation and inducement of a child must be reversed where the charges were brought outside of applicable statute of limitation. 2, whether the district court abused its discretion when it denied defendant's motion to sever the inducement count related to Nia and Pauline from the child P counts related to Jane. Number 3, whether defendant's 240 months above guideline range sentence was both procedural or substantively improper. Statement of the case. On February 13, 2020, the government filed a 13-count superseding indictment charging defendant Kelly with 4 counts of violating 18 U.S.C. 2251A, the child P counts. 2, 1 count of conspiracy to obstruct justice in connection with his 2008 state court acquittal. 3 counts of violating 18 U.S.C. and 18 U.S.C. 2252A related to receiving the aforementioned child P, and 5 counts of violating 18 U.S.C. 2422, the inducement count, docket number 93. Kelly's co-defendant Daryl McDavid and Milton Brown were charged in connection with obstruction of justice and receipt of child P. After 4 weeks jury trial, the jury returned a guilty verdict against defendant as to 3 of the child P counts and 3 inducement counts. Defendant was acquitted as to the remaining count. McDavid and Brown were both acquitted on all counts. Docket number 335. The charges for which defendant was convicted, counts 1 through 3 and 9, related primarily to minor 1 who uses the pseudonym name Jane at trial. 1 inducement count 10, related to minor 3 who used the pseudonym Nia at trial, and 1 inducement count 12, related to minor 5 who used the pseudonym Pauline at trial. The footnote for that one says defendant will refer to minor 5 as Pauline, but advises the court that minor 5 initially used her nickname as her pseudonym, which it also started with the letter P. She later decided that she did not want wished to use her nickname, so the pseudonym changed after trial commenced. Okay. The superseding indictment in the case largely charged defendant with the conduct from the mid to late 1990s. Prior to trial, the defendant moved to dismiss all counts related to exploitation of a child in the statute of limitation grounds. Docket number 189. Defendant also moved pretrial to sever the counts related to Jane from the remaining inducement count where the evidence in connection with child exploitation of Jane included video recording of the prohibitive activity and significantly stronger than the evidence related to the remaining inducement counts. Docket number 196. The district court denied both motion, docket number 222. A. Evidence related to Jane. Jane testified that she was born in September 1984 and was raised in Oak Park, Illinois, R700. When Jane was a junior in high school, she started being homeschooled because she was performing in a musical group with other members of her family, R702. Her entire family was involved in the music industry, R702. Jane was introduced to the defendant through her aunt, Stephanie Sparkle, who was a singer who had collaborated with the defendant, R707 through 715. The defendant and Sparkle had a romantic relationship, R715. When Jane was 13 or 14 years old, she would hang out with the at the defendant's recording studio with her aunt, R716. Jane explained that she would go to the studio and watch defendant record with her aunt, and it was nice to see them working and producing music, R725. Sparkle began encouraging Jane to foster a closer relationship with the defendant, R726. According to Jane, Sparkle told her to ask the defendant to be her godfather and instructed her to sit on his lap and rub his head, R726. Jane wanted to have a closer relationship with the defendant and did what her aunt advised, asking the defendant to be her godfather. The defendant agreed, R727. Jane told her parents that the defendant agreed to be her godfather, and they were pleased, R727. You guys hear this? Are you guys hearing this? All those that claimed that the parents and all this should not be blamed, but okay. But you see how this whole thing was fostered by the family member and how the parents agreed to this. You get what I'm saying? All right, so let me go ahead on and finish reading. Okay. Please hit the like button, share, please. Let others get a chance to hear this. Jane testified that her relationship and conversations with the defendant began to change, becoming more S and leading to phone S. R729 and 730. When Jane was 14, she and the defendant began to engage in sexual contact, R731, 739. The sexual contact involved touching and rubbing each other's genitalia, oral S, and kissing and hugging, R736. These occasions were frequent and occurred at defendant's studio, his home, and his tour bus. R733, 739. Jane's parents allowed her to stay with the defendant, including overnight. R733. After Jane turned 15, she and the defendant started to have sexual intercourse. I have to say it that way, y'all, because I don't want them to ding me. That R736. Defendant started video recording his sexual activities with Jane while she was 14 years old. R766, 771. Jane testified that prior to taking the stand, she viewed video footage at 3 separate sexual encounters with the defendant. One occurred in the living room of his home, one occurred in his bedroom, and one occurred in a room referred to as the log cabin room in the defendant's home. R767 through 68. The video depicted touching and oral but did not involve sexual intercourse. R773. Jane testified that she was 14 years old in all 3 videos that she identified. R771, 778. The 3 videos were introduced into evidence as Government Exhibit 1 and 2. One of the videos was captured by the Government's Exhibit 1, and the 2 other videos were captured on Government Exhibit 2, R773, 779. The 3 videos formed the basis of count 1 through 3 of the superseding indictment. B. Evidence related to Nia. Nia testified that she met defendant in a shopping mall in Atlanta in 1996. She was 15 years old. R2584. Nia was born in August 1980. R2583. If she was born in 1980, August, when did she meet him? Okay, let me stop. Because I was thinking she should have been, when did she meet him? What month did she meet him? I don't see the month she met him. That would make a difference. Okay, because if she met him when she was 16, she was of legal age in Georgia. Nia obtained an autograph from the defendant on which he allegedly wrote down his phone number, R2585. Nia admitted that she did not discuss her age with the defendant and she no longer had the autograph he gave her. So she don't have the autograph. Now, this is her time meeting a superstar. She gets an autograph, but she don't have the autograph anymore. That's what she said. Nia testified that the defendant asked her if she was going to his concert in Atlanta that evening. And let me tell y'all something. That's a lie. 1996 was during the Olympics, y'all. Mr. Kelly did not perform in Atlanta in 1996 in Atlanta because Atlanta was all into getting the Olympics going. Remember, I live here. So that was a lie. There was no freaking concert for Mr. Kelly in 1996 in Atlanta. He had a concert in Maryland in 1996, but not in Georgia. I just wanted to put my little 2 cents in that one. Let me see what you guys are saying. Hold on. Let's see. Yes, Stephanie, the Olympics was going on because I was a volunteer for Olympics and I was meeting people left and right. I was helping out and stuff, I know that for a fact. Trust me, if R. Kelly was here during the Olympics, I would have known, because I knew all the artists that was coming about in that during that time. and he was not one of them. Nope, was not. They had after party with the basketball players and stuff like that. And I don't recall him being here for any of those games because I was responsible for being at the what's that thing? Omni thing. My personal research, there was no Atlanta concert night. No, it's not. It was not. None. She lied, Ash. There was no concert in 1996 in Atlanta. None. They were preparing for the Olympics. They were building all over the place. They had stuff built in Stone Mountain. They built the Olympic Centennial Park downtown. The Omni was getting like being revamped. It was a lot of stuff going on. It was a lot of stuff that was going on down there. And in fact, my friend grandmother at the time she was one of the torch passers in the Olympics, and she did it from downtown all the way to Stone Mountain when they were doing the how they bring the torch to where the Olympic is going to be at. They traveled certain places and they would give it, and she was one of the torch carriers. She just recently passed away 2 years ago, but so I'm very, very well familiar with there was no concert during the Olympics, and that's when the Olympics was here. No, you're welcome, Ashley, because I participated. I was one of the volunteers in the Olympics, and I was responsible for the basketball sessions. I met a lot of people. I met Duncan's was there. I met what's his name? What's it? Because they had all the big basketball players that was here. Duncan Robinson was in it. Dominique, of course. I met a whole bunch of them down there. Whole bunch. I was in my 20s when the Olympic was here. I think I was 29. I think I was 29 at the time. Yeah. Because that during February that same year, I went to Jamaica with my job because they sent me to Jamaica. I was working for GTE at the time. So I remember 1996 like the back of my hand. All right, let me go ahead and finish. Sorry. Nia testified that the defendant asked her if she was going to his concert in Atlanta that evening. She told the defendant she did not have tickets. Defendant arranged for her to obtain tickets. R2585. Nia did not attend the defendant concert, but began calling defendant that evening. R2586-87. Nia explained that she had several conversations with the defendant and that she liked him. According to Nia, the defendant arranged for her to travel to Minnesota to attend his concert. R2591. Nia attended the defendant concert and did not see him until the following morning in her hotel room. Now, you're 15 years old, y'all. You're traveling to another state for someone you don't know. Where's your parent? How in the world are you able to travel all the way to Minnesota by yourself without your parents' knowledge? Where's your parents? Okay. Nia attended the defendant's concert, but did not see him until the following morning in her hotel room. R2598. Nia testified that the defendant kissed her, touched and kissed her breasts, then masturbated. R2602. Defendant told her that he wanted to visit her. Defendant told her that he wanted her to visit him in Chicago, R2602. Now, guys, she's going to travel to Chicago now, and she's only 15? Come on now. Come on. Y'all use your common sense. Defendant did not follow up on the invitation and did not book any arrangement for Nia to come to Chicago. You hear that? He did not follow through on the invitation. Okay? He did not follow up on the invitation and did not book any arrangement for Nia to come to Chicago, R2605. However, Nia made her own arrangement and went to stay with family in Chicago in the summer of 1996 to unbehesting to the defendant. R2605, 2635. Once in Chicago, Nia called the defendant. He invited her to his studio and made no arrangement for her to come there. Nia convinced her cousin to take her to the studio. R2606. Nia arrived at the studio with her cousin, and defendant showed them around and took them to a rating area where they could see him record. Nia and her cousin stayed most of the evening, but defendant was recording and was not hanging out with Nia or her cousins for the most of the evening. R2610. At some point, Nia was told defendant wanted to talk to her in the hallway, and Nia went into the hallway to see him. Nia testified he greeted her with a hug, with a kiss, and held on to her for a moment. And they kind of made out a little. R2611. Nia elaborated, I remember his hand being around my waist on my bottoms, my butt. And then he motions his hands into my pants as we kissed. He fondled my chest and he, kissed. We just kind of made out with the time frame that we were in the hallway. R2612. Nia testified that before she left, she had a second encounter with defendant. She stated that they embraced, hugged, he held on to me, held my bottoms, and things of that nature. But it wasn't as long as the first one. I guess one, that's supposed to be one. It was more like, like kind of like a goodbye, see you later. R2613. Nia never, you hear me? Nia never saw or spoke to defendant again, but in 2002, Nia sued the defendant and the case settled for $500,000. R2615, R2617. C. Evidence related to Pauline. Pauline testified that she was born in October 1984 and grew up in Oak Park, Illinois with Jane, R2288-89. Pauline and Jane became friends in middle school. R2289. Pauline met the defendant through Jane when she was 14 years old. R2289. Pauline explained that when she was 14 or 15, she discovered Jane and the defendant in the log cabin room. Jane was naked. R2292. Pauline testified that she had her first sexual encounter with the defendant when she was 14. R2295. She began having sexual encounters with both the defendant and Jane, which included oral S. R2296-97. Pauline eventually began having sexual intercourse with the defendant when she was around 15 or 16. R2297. Then Jane discovered Pauline was having a separate sexual relationship with the defendant. It became very problematic for their friendship. R2306. Pauline admitted that she continued to have sexual relationship with the defendant until she was grown and was out of college. R 2316. Pauline did not report to any authorities that she had a sexual relationship with the defendant when she was a minor until 2019. The government presented lengthy excerpts of the video recording depicting defendant's sexual conduct with Jane on 3 separate occasions. Much of the government's case centered on the defendant's alleged efforts to obstruct the state's court prosecution of defendant in connection with the videos depicting his sexual conduct with Jane in 2008. The jury acquitted all defendants of obstruction of justice count and all counts related to the receipt of child P. The jury also acquitted defendant to 2 inducement count related to Tracy and Brittany. The jury returned a verdict of guilty against the defendant in connection with the child P counts involving Jane, counts 1 through 3, the inducement count as to Jane, count 9, and 2 additional inducement count in connection with Nia and Pauline, counts 10 and 12. Defendant's post-trial motion was subsequently denied. Docket number 416. The district court judge sentenced the defendant to 240 months imprisonment and above, you hear that? Above guideline sentences. Sentence R70. The district court vaguely referred defendant's obstruction, you hear that? And current sentencing guideline when imposing the above guideline sentence. Sentence R69-70. With the exception of 1 year, the sentence was ordered to be served concurrent to defendant's 30-year sentence imposed in separate prosecution in the Eastern District of New York, NDNY. Sentence R70. This appeals follows. Summary of argument. You guys are still with me? Are you guys hitting the like button? You guys hitting the like button? You guys hitting the like button? I'm going to pause for a minute so we can get the likes up, if you don't mind. We need this information to go out to all the people everywhere. Don't be selfish. Let's hit the like button. Okay, you guys hit the like button? Give me a thumbs up if you hit the like button. Just a reminder, did you guys hit the like button? Just a reminder. I know folks be like, why does she gotta stop? Why don't you just keep reading? Come on, y'all. I am reading, so could you do me that huge favor? Hit the like button. I appreciate it. Don't be selfish. Let others hear it too. Okay. Here's the key. The more you guys hit the like button, the more the information is going to be spread out to others. So do me a huge favor. Hit the like button. Hey, Larry. Thank you, Larry. All right, let's go. All right. Summary of argument. Defendant Kelly was convicted on 3 separate counts in 18 U.S.C. 2251A, stemming from the creation of 3 videos depicting sexual conduct. The reason why I'm saying sexual because I can't say the word. If I do, they kind of ding me. I just want to tell you that, guys. So if you're thinking I'm reading wrong, no, I'm not reading wrong. I'm just trying not to say the word, okay? So if you hear the word sexual, you know what I'm talking about, right? Sexual conduct with Jane, who testified she was 14 years old at the time the videos were created. Defendant was also convicted of violating 18 U.S.C. 2422B as to Jane, with whom she had a romantic relationship that lasted roughly 12 years and a friendship that endured until defendant was indicted in 2019. The jury returned 2 additional guilty verdicts in violation of 18 U.S.C. 2422 as to 2422B as to Nia and Pauline. Nia testified at trial that defendant fondled her in a hallway at his studio on a single occasion when he was 29 years old and she was either 15 or 16 years old. Nia stated that the encounter occurred the summer of 1996, but could not state precisely when. For her part, Pauline testified that she began engaging in sexual conduct with the defendant when she was 15 years old. The prohibited sexual relationship endured long before Pauline became an adult, and she considered defendant her boyfriend. Defendant was acquitted of all remaining counts of the superseding indictment, including an obstruction of justice charge, claiming that the defendant obstructed his 2008 state court prosecution for the production of Child P involving Jane. Indeed, government exhibit 1 was the same video that formed the bias that the defendant's state court charged in 2008, which he was acquitted. Defendant seeks reversal of his conviction on the grounds that the charges of child sexual exploitation and inducement were time barred. Specifically, defendants maintains that the 2003 amendment that extended the statute of limitation for conduct involving sexual abuse was inapplicable to the charges offenses that occurred in the 90s because Congress only intended it to apply prospectively. Thus, the statute of limitation for the charges on which defendant was convicted expired on later than 2009 when Nia and Pauline and Jane all turned 25 years old. Alternatively, defendant seeks a new trial on the induced count related to Nia and Pauline, where the district court abused its discretion when it denied defendant's motion to sever those counts from the Child P counts related to Jane, because the evidence in connection with the Child P counts related only to Jane and was substantially stronger than the evidence supporting the inducement counts related to Nia and Pauline. The inducement counts should have been severed to afford the defendant a fair opportunity to defend those claims. There can be little question that the jury was unduly influenced by the Child P evidence that otherwise would have been inadmissible if the inducement count were severed. Lastly, defendant's 240 months above guideline sentence was procedurally and substantively improper. The district court failed to identify the basis on which he upwardly departed 72 months from the applicable guideline ranging in 135 to 168 months, except to suggest that it was based on an acquitted conduct, that the fact defendant's crime would be punished more severely under the current guideline. Because the district court failed to state a definitive basis for its significant upward variance and violation of the ex post facto clause by subjecting defendant to current federal sentencing guideline rather than the applicable 1997 guideline, defendant is entitled to a new sentencing hearing. Argument 1. I. Defendant's conviction of sexual exploitation and inducement of a child must be reversed where the charges were brought outside the applicable statute of limitation. Because the statute of limitation on the counts for which the defendant was convicted, namely the child P and inducement count, expired no later than 2009, they were time barred. Defendant moved pre-trial to dismiss this indictment on statute of limitation ground. Federal Rule Criminal Procedure P12 B1 and B1-2. Advisory Committee note: the district court denied defendant pretrial motion to dismiss. This court reviewed the legal issue de novo, United States versus O'Brien 953F, in this case number, blah, 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 blah. Federal law imposes a 5-year limitation period for most non-capital offenses. 18 U.S.C. 3282. Over the years, Congress has provided a longer limitation period for the offenses involving the sexual and physical abuse or kidnapping of a minor. 18 U.S.C. 3283. At the time the defendant committed the conduct for which he was charged and convicted, namely the child P counts 1 through 3, the inducement counts 9, 10, and 12, section 3283 provided as follows: no statute of limitation that would otherwise preclude prosecution for the offense involving the sexual or physical abuse of a child under the age of 18 shall preclude such persecution before the child reaches the age of 25. 18 U.S.C. 3283, 1994. Consistent with the foregoing provision, at the time of the charged conduct, the statute of limitation for offenses involving sexual abuse were extended until the victim/minor reaches 25 years old. Thus, Section 3283 extended the 5-year limitation period for the conduct alleged in counts 1 through 3 and 9 of the superseding indictment until September 2009, when Jane reached her 25th birthday. The statute of limitation for counts 10 was extended until 2005, when Nia turned 25. And the statute of limitation for counts 12 was extended until October 2009, sorry, not 29, to October 2009, when Pauline turned 25. Defendant was not charged until more than a decade after the expiration of the statute of limitation under the applicable law at the time of the alleged conduct. Unless subsequently amendment to Section 3283 apply retroactively, in this case, defendant's conviction must be vacated and dismissed as time barred. In 2003, Congress amended the statute, extending the statute of limitation through the life of a minor. 18 U.S.C. 3283, 2003. Congress did not express its intent for the 2003 amendment to be applied retroactively. Consistent with the well-established presumption against retroactive litigation, the 2003 amendment is inapplicable to the charge conduct as is any subsequent amendment in Section 3283. See United States versus Dia. Okay, apply to version USA, blah, 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 blah. The footnote 2 says Congress amended the statute again in 2006 to its current version, which provides a limitation period for life in the victim or 10 years after the offense, whichever is longer, 18 U.S.C. 3283. 3283 in effect at the time of the defendant's offense rather than the amended version in effect at the time of the indictment. It is axiomatic, or whatever the word is. Axiomatic, whatever. The criminal limitation status are to be liberally interpreted in favor of repose. Torsi versus United States. Tusi versus United States. Retroactively is not favored in the law. Vanquez Garcia versus Holder. Bowen versus Georgetown University. Okay, the Supreme Court has explained that this aversion to retroactive rule making is deeply rooted in our jurisprudence, whatever that is, and embodies a legal doctrine century older than our republic. Elementary consideration of fairness dictate that individuals should have an opportunity to know what the law is and to conform their conduct accordingly. Settled expectations should not be lightly disrupted. For that reason, the principle that the legal effect of conduct should ordinarily be assessed under the law that exists when the conduct took place has timeless and universal human appeal. Landgraf versus USI Film Products. With these principles in mind, the district court erred when it retroactively applied the 2003 or 2006 version of Section 3283 and denied defendants' motion to dismiss on statute of limitation grounds. The United States Supreme Court in Landgraf set forth a framework for determining whether a federal statute of limitation applied to past conduct. The court's first task is to determine whether Congress has expressly prescribed the statute proper reach. If Congress has done so, of course, there is no need to resort to jurisdictional default rules. When, however, the statute contains no such express command, the court must determine whether the new statute would have retroactive effect, i.e., whether it would impair rights a party possesses when he act increase the party's liability for past conduct or impose new duties with respect to transactions already completed. If the statute would operate retroactively, our traditional presumption teaches that it does not govern absent clear congressional intent favoring such a result. ID Act 280. Thus, under Landgraf, if Congress had expressly prescribed that a statute applies retroactively or will not apply retroactively, the inquiry ends. If the statute is silent on the issue, courts proceed to second step of the Landgraf analysis and determine whether the new statute would have retroactive effects. ID here. The 2003 amendment of Section 3283 contains no language expressively prescribing retroactive application of the amendment. Although the statute does not expressly provide that it may only apply proactively, it employs language that points toward prospective application. The section twice uses forward-looking modal verb, would and shall, 18 U.S.C. 3283, and no statute of limitation that would otherwise preclude prosecution for an offense involving the actual or physical abuse or kidnapping of a child under the age of 18 shall preclude. See Appalachian Power Company, EPA, characterizing the phrase would admit as future conditional phrase. Holding, whatever. There is no doubt that shall an imperative, but it is equally clear that it is an imperative that speaks to future conduct. Martin versus Hunter, Lee C. The word shall is a sign of the future tense. The legislative history of the statute further supports defendants' contention that Congress used prospective language in the statute to evince its intent that the statute apply prospectively and retroactively. Critically, Congress considered and rejected language that expressly prescribed retroactive effect, showing its intent that the amendment only apply prospectively. In fact, the House of Representatives version of the bill provided for the complete elimination of a statute of limitation and include an express retroactively provision declaring the amendment made by this section shall apply to the prosecution of any offense committed before, on, or after the date the enactment of this section. Child Abduction Prevention Act RH 1104, 108, Congress 202, 2003. The Senate version contained no retroactivity provision. Project Act S 151, 108, Congress. When the House and Senate conferred to resolve the difference between the bill, the retroactivity provision was omitted. Senator whatever, one of the bill's original co-sponsors and former chair of the Senate Jurisdictional Committee, stated on the Senate floor that the omission was intentional. I am pleased that the conference agreed to drop language from the original House-passed bill that would have extended the limitation period retroactively. Senator Leah Amber legislation, whatever, Congress, REC, the legislative history of the bill expresses Congress' intent that the amendment apply prospectively. See Martin versus Haddix, explaining structure and litigative history as part of first Landgraf steps. See also Food and Drug Admin versus Brown and Williamson Tobacco Corp. Labatt versus Ashcroft. Our inquiry is not limited to the statutory text, but may include an examination of standards in sign of statutory structure, such as the statutes struck and litigative legislative history. In some, Congress affirmatively reject the proposed retroactive application provision, indicating its intent that the statute apply prospectively. Even if this court concluded that Congress' intent is not expressed, retroactive application of the 2003 amendment fails to pass the second prolong the of the Landgraf test. The United States Supreme Court held in Stogner and California that the retroactive application of extended statute of limitation to revive time-barred claim violate the ex post facto clause. The district court held that the 2003 and 2006 amendment did not revive time-barred claims in this case, but rather extended the limitation period for prosecuting those offenses before the limitation period. Hold on a second, y'all. I got a call coming in. Hold on. Hello? Sorry about that. The stupid telemarketers. Sorry about that. Okay. Admittedly, this court rely on Stogner has held in different circumstances that extending a limitation period before a prosecution is time barred does not run afoul, but the ex post facto cause. See United States versus Gibson. However, the defendant maintained that an analysis of the retroactive activity of a criminal statute of limitation under the second step must recognize the principle that unlike civil statute of limitation, criminal limitation are to be liberally interpreted in favor of repose. To see also United States versus Gentile. Observing that if Landgraf and Toucey are read in conjunction, courts must interpret the statute of limitation in a manner favoring the repose for defendant. As the First Circuit acknowledged, Toucey potentially altered the second step of the Landgraf approach in the criminal cases. United States versus Miller. Evaluating 2003 amendment in educating in effect assistant the counsel claim. In other words, when Congress had sounded on an uncertain trumpet, a court ought to refrain from applying enlarged criminal statute of limitation retrospectively. ID as discussed Congress sounded an uncertain trumpet regarding the retroactivity of the 2003 amendment when it affirmatively removed a retroactivity provision from the bill. In light of Toucey, this court should reject the retroactive application of 2003 amendment, even if it is not the equivalent of an ex post facto violation, because it runs afoul of familiar consideration of fair notice, reasonably reliance, and settled expectations. But differently, defendant urges this court to read the second step of Landgraf as providing broader protection for criminal defendants than the ex post facto cause. Statute of limitation applicable to criminal prosecution are designed principally to protect individuals from having to defend themselves against charges supported by facts that are remote in time. Oh, sorry, a little bug on me. United States versus Rivera and Ventura. That concern was acute in this case, where the government sought to rely on retroactive extensions of criminal statute of limitation to prosecute a case based on conduct that is more than 2 decades old. Retroactive application of the 2003 amendment not only flies in the face of congressional intent, it violates notion of fundamental fairness. In sum, Section 3283, by its language and its legislative history, was intended to apply prospectively. The inquiry ends there. But even if this court examines the question under step 2 of the land graph, the analysis, it should decide against retroactive application of the amendment. Accordingly, this court should vacate the defendant's conviction as time barred. Number 2, trial court abused its discretion when it denied defendant's motion to sever the inducement counts 10 through 13 from the child P count related to Jane, count 1 through 3. Defendant suffered unqualifiable prejudice by the joinder of the child P count related to Jane with various inducement counts related to the other minor. Because the government's evidence in connection with charges related to Jane was significantly stronger than those counts to Nia and Pauline, the district court erred when it refused to sever the non-Jane inducement count from the rest of the indictment. This court should vacate defendant's conviction for violation of 18 U.S.C. 2422 as 22B as to Nia and Pauline and remand a new trial on those counts alone. This court reviewed a district court's decision. Oh, it's this little flying thing keep getting on my nerve, y'all. Sorry. The court's decision to deny a motion to sever the counts of an indictment for abuse of discretion. United States versus Smith. Federal Rule of Criminal Procedure 8 allows for joinder of counts where offenses are of the same or similar character, or as based on the same act or transaction, or connected with or constitute part of a common scheme or plan. However, Rule 14 relief of presidential joinder provide the severance in cases of substantial prejudice. United States versus Wennard. Rule 14 states, A, relief. If the joinder of offenses or defendants in an indictment, an information, or a consolidation of a trial appears to prejudice a defendant or the government, the court may order separate trial of counts, sever the defendant's trial, and provide any other relief that justice requires. Court have recognized that substantive prejudice result from joining charges that are supported by relatively strong evidence with charges supported by much weaker evidence. United States versus Alvarado. IEC United States versus Fonts, where difference in the strength of two cases were great. We cannot presume that the jury adhered to limiting instruction and properly segregate and the evidence into separate intellectual boxes. Citation omitted. United States versus Ragahiti. Reverse trial court determination that severance was not required where there was strong evidence of a robbery and weak evidence. Oh my God, this stuff is getting on my nerve. Evidence on the other. Gregory versus United States. In this case, the child P counts 1 through 3 of the indictment were supported by video recorded evidence. Video recorded evidence reflecting the prohibited actual contact with Jane is dramatically stronger evidence than the 25-year-old testimony evidence of Nia and Pauline. Indeed, as to Pauline, the question on when her sexual relationship with defendant commenced was a hotly contested issue. Pauline testified that she began having sexual relationship with the defendant when she was under 17 of age. She had previously denied. Oh, y'all, hold on. This thing's getting on my nerve. Sorry, there's a little fruit fly here to keep bothering me. She previously denied any actual relationship with the defendant as a minor, including under oath, and only reported actual relationship with the defendant as a minor in 2019. Pauline also testified on direct examination that she recalled drinking a liquor known as hypnotic when the defendant during the period of time when she was a minor and engaged in actual activity with him, to the R2305. But the defendant presented evidence that hypnotic was not available to the market until Pauline was 17 of age, relying on her claim that she began actual activity with the defendant when she was underage. R3611. Notably, there was no video evidence that reflected Pauline's actual activity with the defendant, and she claimed to never have seen such evidence. The point here is that the evidence related to Pauline and Nia turned mostly entirely at 25-year-old testimony, largely uncorroborative rather than the video evidence and actual explicit conduct with a minor. There can be little question that the jury assessment of the evidence as to Nia and Pauline was greatly influenced by the child P evidence as to Jane. The defendant had a little chance of persuading the jury that the government failed to meet its burden in connection with charges related to Nia and Pauline, where any doubt the jury may have harbored would have pushed aside in light of the dramatically stronger evidence on counts related to Jane. Similarly, substantial prejudice can result where a defendant has important testimony to give on one case and a strong need to refrain from testifying on the other. Cross versus United States. United States versus Archer. Baker versus United States. United States versus Eli. In Baker, the D.C. Circuit Court observed, prejudice may develop when an accused wishes to testify on one but not the other of two joint offenses, which are clearly distinct in time, place, and evidence. His decision whether to testify will reflect a balance of several factors, which respect to each count, the evidence against him, the availability of the defense evidence other than his testimony, the plausibility and substantivity of his testimony, the possible effect of demeanor, impeachment, and cross-examination. But if the two charges are joined for trial, it is possible for him to weigh factors separately as to each count. If he testifies on one count and he runs the risk that Any adverse effect will have influenced the jury's consideration of the other count. Thus, he bears the risk on both counts, although he may benefit on only one. Moreover, the defendant's silence on one count would be damaging in the face of his express denial of the other. Thus, he may be coerced into testifying on count upon which he wishes to remain silent. It is not necessary to decide whether this invades his constitutional right to remain silent, since we think it constitutes prejudice within the meaning of Rule 14, Baker versus United States. Recognizing that sometimes circumstances can coerce a defendant into testifying on a count upon which he wishes to remain silent. In light of the foregoing, the district court erred in it denied defendant's motion to sever the inducement counts related to Nia and Pauline. As defendant set out in his motion to sever, he had important testimony to give in connection with the inducement count related to Nia and Pauline, but had no choice to forego giving the testimony in order to maintain his right against self-incrimination in connection with the other counts of the indictment. Indeed, this is precisely the scenario that that justifies severance, because the defendant would have been coerced into testifying on a count upon which he wishes to remain silent in order to give testimony concerning count 10 and 12. Joinder of the counts related to Jane and the other counts related to Nia and Pauline served to prejudice the defendant. Severances was particularly justified here, where the inducement counts were only similar to the Child P counts as to Jane, in that they both involve sexual explicit conduct with minors. United States versus Coleman. Overruled on other grounds, the inducement counts related to Nia and Pauline are of similar characters to the counts involving Jane, but they involve different acts and largely different evidence. But because of the similar nature of the counts involving Jane, the risk of prejudice was acute, because the jury concluded that the defendant was guilty of the Child P, for which there was significantly stronger evidence. It likely did not bother to consider whether the government satisfied its burden in connection with the inducement count related to Nia and Pauline. The district court should have severed the inducement count from the Child P count to afford the defendant a fair shot of defending those claims, which turn on 25-year-old testimony that defendant sought to challenge. All right, I need a break for a minute. I gotta get me some water. Hold on. I've been reading this thing too long. Hold on, y'all. I need to get some water. Hold on. My throat's getting dry. Hold on. Let me put some music on while they all wait on me. Hold on. Hold on. All right, I'm back. Sorry. I didn't get my something to drink and my throat was dry. Now hitting the like button while y'all listen to this? Because I'm working hard for you guys. Oh, sorry, you guys. Sorry. Woo! I was drinking this kombucha and water. All right, hold on. All right, let's get back reading this stuff. I'm gonna stop at a certain point, you know, right? Because I gotta get myself ready for some other stuff that's going on my channel today. All right, we are on 3. Defendant's 240-month above guideline sentence was both procedurally and substantively improper. Defendant was sentenced to 240 months imprisonment, a sentence that was significantly above the applicable guideline range calculated at 135 to 168 months. After correctly calculating the guideline range, the district court sentenced defendant to a sentence that was 4 offense level above the applicable guidelines range. The district court stated for applying a significant upward variance was ambiguous and unjustified in any event. Indeed, the district court's sentence appeared to be motivated by acquitted conduct and considered the current federal sentencing guideline, which reflected greater punishment on child exploitation cases, but which were not applicable to the defendant's 1990s conduct. Accordingly, this court shall vacate the defendant's sentencing and remand for resentencing with direction that the district court sentence the defendant to a guideline sentence and expressly identifying the basis upon which an above guideline sentence was appropriate. You know what? That is very good, y'all. I'm gonna just tell y'all. I'm not a lawyer, but when me and Miss Guided was talking, we talked about that. Sure did. And we're not even lawyers. In reviewing court's review on de novo, a procedural challenge to the defendant's challenge and the substantive reasonableness of the sentence for abuse of discretion. Ooh, child. United States versus Ballard. A district court should begin the sentencing procedure by correctly calculating the applicable guideline range, which should be the start point of the initial benchmark. Gall versus United States. After a proper calculation, the sentencing judge considered the 7 factors set forth in 18 U.S.C. 3553A. The nature and the circumstances of the offense, the history and characteristic of the defendant, the 4th legitimate purpose of sentencing as set forth below, the kind of sentences available, the applicable guideline ranges itself, and a relevant policy statement by the Sentencing Commission. The need to avoid unwarranted sentencing disparity among the defendants and the needs to provide restitution to any victim. 18 U.S.C. 3553 A1-7. See also Gall 55, whatever. I'm not going to go read that. The statute directs judges to impose a sentence sufficient but not greater than necessary to comply with the purpose of sentencing 18 U.S.C. 3553. Defendants largely agreed that the district court sentences analysis, but objects the court's above guideline sentence that appeared to be based on acquitted conduct. Remember we said the conspiracy to obstruct justice? Okay. And current sentencing guideline rather than the applicable guideline, although the court was not entirely clear on his basis for imposing an above guideline sentence. The district court concluded that the applicable combined offense level was 32, which resulted in a guideline between 135 and 168 months. Imprisonment under the 1997 federal sentencing guideline. However, when imposing a 240-month sentence, the district court did not expressly state his basis for an above guideline sentence. Instead, vaguely suggests a basis for an upward variance. The court stated, I'm going to do his voice. So, anyway, as far as I was going to sentence Mr. I would probably have considered all the factors that I outlined before. I would have probably had a variance upward from the top end of the guidelines, which was 168. Again, I think that there is some evidence, justification of the obstruction, and so because of the increase in the current guideline, so that I am all probability, if I was sentencing Mr. Kelly as a result, I would probably have given him a sentence in probably neighborhood of 240 months. So I will. It seems to me that under all the facts and circumstances, there is a valid sentence, 240 months. I was just Judge Lineweber just now. This court has acknowledged that because the guidelines are advisories, district judges have discretion to sentence a defendant outside the calculation. Guideline range is bolder. This holding is consistent with 5K2.0 of the 1997 federal sentencing guideline, which observed that the sentencing court may impose a sentence outside the range established by the applicable guideline. If the court finds there is existing an aggravating or mitigating circumstances of a kind, or to a degree not adequately taken into consideration by the Sentencing Commission in formulating the guidelines that should result in a sentencing from that described. However, when a sentencing court does not impose a sentence that varies from the applicable guideline range, it must consider the extent of the deviation and ensure that the justification is significantly compelling to support the degree of variance. Ballard, you got the case number, United States versus Miller. The judge explanation of the deviation must articulate and justify the magnitude of the variance. ID cited United States versus Conaway. It follows that more significant justification is necessary. For more substantial departure, ID cited United States versus Castillo. Failing to adequately explain a chosen sentence, including an explanation for deviation from the guideline range, is a procedural error, ID at 437. In this case, the district court's 240-month sentence is both procedurally and substantively improper. As the record reflects, the district court fails to clearly articulate on what the basis he sentenced the defendant to a term of imprisonment that exceeded the maximum guideline sentence by a whopping 72 months. The district court hinted at the ground of its above guideline when it vaguely referenced obstruction and current guideline. But the record is far from clear. Moreover, the grounds that the district court referred as his basis for a 20-year sentence appears to be based on, at least in part, on the court's view that the defendant's obstruction justice, presumably in connection with the conduct related to his state court conviction for which he was acquitted. While obstruction might permit an enhancement of the offense level, the obstruction enhancement related to the obstruction in the instance offense, not an obstruction charge which defendant was acquitted. There is no claim on any part that the defendant attempted any of the obstruct this prosecution. Defendant recognizes that this court and the United States Supreme Court have held that acquittal conduct may be considered by the sentencing court as long as that conduct has been proven by the preponderance of the evidence. See United States versus Halton, citing United States versus Watts. See United States versus Brown. Millett J. concurrent, condemning the use of acquitted conduct as basis for increasing the length of imprisonment. United States versus Cananea. Bright J. concurrent, opinion that was acquitted conduct in sentencing violation the due process clause of the Fifth Amendment and undermined the principle of fair notice. In this case, however, the district court merely hinted at its right to make such a finding. Senate R 63. The district court never expressly or ambiguously found that by the preponderance of the evidence standard, defendant had obstructed his 2008 prosecution as the government charged in its indictment, nor did it identify that the fact it credited in making the finding that the defendant obstructed justice by the lower standard. Indeed, the district court made no mention of any conduct on the part of the defendant that he would have allowed it to conclude that the defendant obstruct his 2008 criminal prosecution by the lower standard of proof. Rather, the district court mentioned the defendant's minions had started, rather than Keystone Cop kind of operation, to keep tapes back. But this conduct, even if credited under the lower standard of proof, was not evidence of obstruction, of obstructing defendant's 2008 state court prosecution based on a tape that was already in state's possession. The district court seems to be referring evidence related to conspiracy to receive child P, by which the defendant was also acquitted, not the obstruction of justice. The record is simply unclear as to related to what the fact that the district court relied on its concluding that an upward variance based on obstruction was justified. Assuming that acquitted conduct may be used to justify an upward variance without violating the due process clause, as to this court has held, and sentencing court must at a minimum make such finding and explain how it reached the conclusion that the defendant had committed the acquitted conduct by the lower standard of proof. The district court judge failed to do so here. Even more problematic, the district court violated the ex post facto clause when it sentenced the defendant to above guideline sentence simply because the current sentencing guideline generally calls for a higher offense level than the applicable 1997 sentencing guideline. Pugh versus United States. The United States Supreme Court has held that it is an ex post facto violation when the defendant is sentenced under guideline promulgated, whatever, after he committed the criminal act, and a new version provide a higher applicable guideline sentencing ranging than the version of in place at the time of offense. It is true that this court has held that a district court at sentencing one may interpret the commission later edition of the aggravating element as a sentencing factor as evidence that a previous version of the guideline did not adequately consider that factor in the sentencing scheme, and two, may also consider later amendment for determining how much a departure is warranted for the aggravating conduct in question, United States versus Coe. However, Coe does not stand for the proposition that the district court may upward departure for the applicable sentencing range by merely pointing that had the defendant committed this crime today, his offense level would be greater. Unlike Coe, the district court here did not identify any recent amendment or specific aggravating elements codified in the current guidelines, but not the 1997 guideline that justify a significant upward variance. Further, the district court did not identify any aggravating element that were omitted as a sentencing factor in the applicable 1997 guideline, which exists in recent iteration. Oh, whatever. I'm getting tired now, y'all. Iteration of the guidelines. Rather, the court simply observed that the offenses for which the defendant was convicted now carries a higher base offense level than they did in 1997, imposing an above guideline range for no reason other than the current guidelines are generally more punitive in textbook ex post facto violation. In some defendants, 240-month guideline sentences was procedurally improper where the district court failed to identify the grounds on which he was imposing a sentence of 72 months higher than the maximum guideline sentence. To the extent the district court relied on acquitted conduct to justify the upward variance, it failed the state ambiguously, but it found that the defendant committed a certain acquitted conduct by a preponderance of evidence. Furthermore, defendant's sentence run afoul of ex post facto clause where the court justified its upward departure sentence because the defendant would be punished more harshly today than the same conduct that what the 1997 guidelines demanded. Accordingly, defendant's sentence must be vacated and the matter remanded in a new sentencing hearing where the defendant is sentenced to a guideline sentence and where the court specifically identified basis for the upwardly departure for four offense level. Conclusion. For the foregoing reason, defendant conviction must be reversed. Alternatively, defendant conviction at the counts 10, 12 must be vacated and remanded for a new trial. Lastly, defendant is entitled to a new sentencing hearing. Respectively submitted, Jennifer Bonjean. I'm tired. Okay, this is all her sentencing. Certified. Certificate of thing. And this is the appendix. This is all the other stuff that was evidence stuff that was from the previous case. Okay, here's the order, dismissal, the denial, all that other stuff. just stuff from the old case, okay? There's nothing to be read. This is stuff from the old case, okay? You guys got it? Any question? I'm so tired of reading. I started getting tongue-tied at y'all for a minute. I'm so tired of reading. I was so tired of reading. My throat got dry. Tired. You're welcome. You're welcome. That's basically it. All the other stuff, guys, is just like stuff from the case that they've added in there. You know how they add all like transcripts and all that stuff. There's 77 pages of that kind of stuff, but it's just stuff that was added on. Anybody have any questions? I think those and you know, funny thing is Miss Guide still in here. Miss Guide, are you still in here? Miss Guide, are you still in here? Oh, thank you, Amber, for the Cash App. Thank you. Let me put my music on. Thank you. Thank you. Thank you for showing me some appreciation, Amber. I appreciate you, darling. Thank you for the folks. Thank you, Amber. Those who did, I mean, I even asked those to hit the like button. They don't even appreciate that me doing the reading, even though I hate reading, and they don't even appreciate it. But that's okay. That's okay. God's still gonna bless. God is still gonna bless them. But I'm about to hit the road because I got an interview to do. I have an interview to do at 7:00. I have another paperwork to show with the Rondo guy. Also the motion that Mr. Stillwell showed. I gotta do that. I got all of that stuff going on. Hold on. Wait a minute. I just saw. Okay. I just missed though. Let me. Trissy, thank you. Hold on. Let me do my music. Hold on. Trissy, hold on. Let me do my music. I do Trissy. That's for Trishy. Now here's from Kim. Another Cash App. Lord, thank you, Jesus. Money, so much money. Thank you, Kim and Trissy. I appreciate y'all. So much money. Money. So much money. Thank you, guys. Thank you. Thank you so much. It makes my heart feel really good that I got some individuals who appreciate the work that I'm doing. I thank you so much, ladies. Thank you. Oh, you don't know how much I appreciate what you guys just blessed me with. I will see you guys later. I have to get myself ready for the other live. I do have an interview I'm doing tonight in regarding to, you remember they have the motion regarding the GOAT situation, a goat sacrifice, I have an interview from in fact, the oh Steph. Okay, hold on. Gotta do my money song for Steph. Thank you, Stephanie. Thank you guys. Oh my God. You guys are making me so like grateful. I don't have to go out there. I don't have to worry about, oh, you're gonna watch the replay. Thank you, SOS. Thank you for the awesome job that you're doing. And I thank you for giving me that little shine. Thank you, SOS. I appreciate you so much, so much. I appreciate you. You guys, man, make it worth my while. And I don't even have to go. Well, I'm not gonna go out there and do that Grubhub today, because you guys helped me to make some sort of like justification of why I didn't go out there today to get in that heat. Thank you so much, y'all. Thank you, thank you, thank you, thank you, thank you. Didn't meet my goal yet, but thank you, thank you. I appreciate y'all. But as I was saying, I have a guest that's coming on. Might be a couple of people that is going to give us some education of the there was a motion submitted by Thug's attorney having to do with some sacrifices, right? They were talking about the animal sacrifice, but I have the leader of that that religion who's going to come and talk to you guys about it. That's going to talk to you guys about the whole situation. So you guys, education is, I'm not trying to change anybody's religion or nothing like that. No, that's not what I'm doing, because I believe in Christ. That's where my stance is. But God also give us the ability to learn about other things that we should. Ignorance is not a good thing. Knowledge is power. If you have knowledge of certain things, you don't have to know everything, but have understanding of certain things and know why certain people do certain things. You'll understand and not be walking around ignorant of some of the facts, right? People think, oh, just because, oh, you don't operate in that, but you need to know. You need to know what's out there, y'all. What you don't know will hurt you sometimes. So you need to know. You need to know certain things. My husband and I used to get into discussion because, I don't like watching news and all that. And he's very much into politics and all this kind of stuff. And he tried to educate me, and I'll be like, I don't want to hear that. But then he's like, Sylvia, you need to know this stuff. Just because you don't know does not make it not happen. You know what I'm saying? So we got to be educated. We got to open up our mind. And so I will be bringing the leaders of that organization. And I was going to tell you that the religion is called IFA. IFA is the religion. Is a Western Nigerian religion. And so I will be reading all that to you guys later on, and we're gonna dive in. We're gonna dive in and understand it. And we stay prayed up, y'all. Plead the blood. Plead the blood. But if you're strong in your relationship with Christ, none of that stuff should even affect you. You know what I'm saying? But understanding is power. But you guys, what do you guys think about the motion and the paperwork that Jennifer has submitted? Let me put the link in here just in case anybody want to say something, because I'm about to get off in a few minutes. But I just want to see you guys' input and see, what do you think? What do you think about what she submitted? And she has to submit the original paper. I guess in that area they have to show paperwork. They have to submit the paperwork to let me show you. Hold on. So you guys know what I'm talking about. Hold on. They have to submit the actual paperwork to let me show y'all. Okay, this is what they have to do. They have to submit by the 9th paper copies of the actual what they submitted there. And then they have to fill out the form just in case they want to do a oral argument, and have to mail it shortly before the date of let me just read this. It says appellant brief filed by appellant Robert Sylvester Kelly. Paper copies are due on 8/9/2003. Reminder, if a case is designated to proceed to oral argument, hearing notice will be mailed shortly before the date of oral argument. Please note that counsel unavailability for oral argument must be submitted by letter. Filed electronically with the clerk office no later than the filing of the appellate brief in a criminal case and the filing an appellee brief in the civil case. See Circuit R34B3. The court calendar is located, and they give a court calendar link. Oral argument is rescheduled only if extraordinary circumstances. So we will know if they have motion for oral, like the other one. Remember the other one? They have an oral argument that is set. So this is just telling you that they have by the 9th to get the paper version in it. Oh, I forgot, Kim. Queen, let me see what you guys saying. I think it's very good and interesting. T Girl says, Queen says all we can do is pray. Stephanie says, I'm very pleased. I think she captured all the injustice. Sharon said, have a good afternoon, a true awesomeness. Kimberly says, dismissal. Steph says, Jennifer is very thorough. Kimberly, I know I messed up with my watermark. I didn't put my watermark up. Oh, well. And Devin says, hi, good evening. It was about today. What was about today? Devin, you're going to have to go back. It's been 2 hours of me reading this thing. Devin, you're late. You late to class. You know, when you're in school, the teacher don't stop and start over and what. No, you're going to have to find it from your classmate, the answer. When you're late to class, we will not do that, okay? Go back and look at replay. That's why they have replay. All right, so I'm about to take my butt on so I can get prepared for the next couple of paperwork that I have. Again, thank you everyone who has hit the like button, everyone who has donated. I truly let me call out the people that gave me the donations again, because I want to show you guys how much I appreciate you for what you have done for me. Let me call some of you guys out again. Oh, I did get some more. Okay, hold on. Aw, Misguided, thank you. Let me play Misguided music because I played you guys music already. Hold on, let me play Misguided. Here's for you, Misguided. Okay, so here's the people I want to thank for their donations today. Red Bunny, thank you. Amber, thank you. Trissy, thank you. Kimberly Black, Thank you. Stephanie, thank you. Misguided, thank you. Thank you. Thank you. Thank you guys for your blessing. Thank you. Laquitha, thank you. Miss Pretty Brown Eyes, thank you. Thank you guys. I appreciate y'all. Appreciate you for showing me some love and appreciation. You guys really rock. I'm almost there for not for not having to go to work. So you guys, thank you. But I have to go so I can go to the next stage of getting the stuff prepared. I appreciate y'all for everything you do, for all the likes that you're hitting the button, for sharing, and for being here. Without you guys being here, there would not be a channel. So I thank you guys for being here. Whatever you do, being here counts. Trust me. Kudos to you guys. And again, see you later, guys. Love you. And I'm going to pray for the babies. One more time for the babies. Steph, where my babies at? Give it to them. Give this to them. And don't forget to text me the names now, okay? Steph, don't forget. You and Lady, I already know Lady Coltrane babies. I'm going to say all their names so one day when they listen, they can hear their name on the live. They're like, oh my God, she just said my name. You know how precious that is. I'll see you guys later. Love y'all. Bye.
Okay, ready? 1, 2, 3. Hold on now. Wait a minute, fellas. Wait a minute. I think it goes something like this. Whoa. 1, 2, 3, 4, 5, 6. Can somebody take these burdens off of me? Off of me. Can somebody take these burdens off of me? Off of me. Cause every time I turn around, there's something trying to keep me down. Can somebody take these burdens off of me? Off of me. Whoa. Can somebody take these burdens off of me? Off of me. Can somebody take these burdens off of me? Off of me. When I look up, don't you know, burdens knocking at my door. So won't you come and take these burdens off of me? Off of me. Oh, come and take these burdens off of me. Off of me. Somebody come and take these burdens off of me. Off of me. Soon as I get up off the ground, my burdens knock me right back down. Can somebody take these burdens off of me? Off of me. Somebody take these burdens off of me, off of me. Somebody take these burdens off of me, off of me. Somebody take these burdens off of me, off of me. Well, off of me, off of me. Oh, off of me, off of me. Well, off of me, off of me. Get them off of me, off of me. Come and break the chain. Come and break the chain. Get it off of me. Get it off of me. I need somebody. I need somebody. I need somebody. I need somebody to get this burden. To get this burden. Can somebody take these burdens off of me?